Okay, so we have had a very interesting last couple of weeks. Let me start by taking you through what's been happening, and then just kind of giving you a quick summary of the last couple of weeks. I'll answer the questions that we've received, and then we can open it up. So as you know, we had the mediation, or not mediation, it's the confirmation hearing that's been going on for the past about 2 weeks. It ended earlier this week. And there were a number of issues that we had to resolve. The main two are the ones that have received a lot of talk in the press. And of those, the main one is the registration rights agreement. So, and just in case anybody is not familiar with what that is, what happens is that whenever you have a large offering of stock, there has to be an agreement that sets forth what the conditions are for selling that stock. And so here, PG&E is going to be selling somewhere between $9 and $12 billion worth of stock over the next little while, in addition to giving roughly $6.75 billion, looks like it might be a little bit higher than that, worth of stock to the trust. And so one of the issues that we wanted to make sure of was that the terms that were put on the trust's ability to sell the stock were not any more restrictive than were put on anyone else. So in other words, if there was a limitation of selling for 90 days or 180 days or something like that, we didn't have any objection to that, but we wanted to make sure that it wasn't a situation where there was one standard for one group and then the trust was at some kind of a disadvantage. So I'm pleased to be able to say we've gotten that resolved. It was resolved earlier this week, and it's going to be the same for everybody. So that's a big deal. That's now resolved. It's off the table. The only remaining issue that is of importance for us, and I want to clarify, anytime you have a bankruptcy, particularly one of this size, there are always a million little issues. You'd be amazed at how many people that have nothing to do with fire victims came in and would make points regarding certain parts of the plan. And if any of you took a look at the plan, I mean, it's hundreds of pages long. And so it's understandable that there would be little issues where
You're muted, Jerry.
All right, one sec, Jerry. We have a technical issue here.
Okay, how about now? Is
You're
that better?
fine.
Yeah.
Okay. Okay, good. So again, most of the issues that were raised in the confirmation hearing, and this is why the confirmation hearing took about 10 days, had very little to do with us. We had our main issues, but most of the issues were tangential. It might be that a certain creditor was saying, you're saying I'm entitled to X and I think I'm entitled to Y. Those kinds of issues, again, not issues for us. The main two for us were the registration of rights, which has been resolved, and then this other issue of net normalized income. And that was important because, as we talked about before, the way the stock is being calculated is 14.9 times the net normalized income. So as long as the net normalized income was in the general range where we thought it was going to be, which was slightly over $2 billion, that was fine. Based upon the 22% that we were going to receive, by we, I mean the trust, that was going to be 6.75 billion or slightly higher. So there were all kinds of issues that came up, but we've now settled on the net normalized income. It's over $2 billion. I believe the exact number is $2.079 billion. I could be off a little bit, but it's right around there. And then in terms of the percentage that the trust is going to get, it's over 22%. So it is going to be over that 6.75 billion. So all that worked out the way that we wanted. And so now it's just a question of the judge issuing the confirmation order. And the reason that it probably will take him, maybe 10 days or so to get it done, is that, again, he has to go through and resolve the hundreds of little objections that were made. He'll get a final order out. Again, should be end of next week, might be a little bit longer, but it'll definitely be before June 30th. So now we switch gears, and now we're pretty much completely focused on the claims resolution procedures. In terms of those, we're still working with the trustee and the claims administrator. We don't have everything finalized yet, but we are on track to hopefully get that done by July 1st so that we can start submitting right after July 1st. So again, if there's any documents that you have that demonstrate your losses that you haven't provided, please do that as soon as possible. The most important thing for all of you to be working on, again, is the personal property list. That's the critical one. That's the one that we really can't do. If it's going to be done, it is going to have to be done by you. We can certainly help with it, but only you know what you had. So if you need assistance, please let us know. But that's the biggest thing for all of you to be working on now. So let me go through the questions that we got for today. And after that, I'll open it up and take questions. First question is, most insurance companies have preset limits on certain categories of items, such as jewelry and antiques, of which you can claim for replacement. Do any such restrictions exist in the lawsuit? Are there types or categories that are not allowed? It's a good question. The answer is no. There are absolutely no limits on the suit in terms of what you can recover. So let's say, for example, you had a more extensive jewelry collection than most people. You know, most people will have maybe a few $1,000s worth of jewelry. Let's say that for some reason you had $45,000 or $50,000 worth of jewelry, but the limit on your personal property was $10,000. You can absolutely seek the balance there, $35,000 to $40,000, from the lawsuit. That's what it's there for. The same is true of antiques. Again, any type of limit, once you reach the limit in the insurance policy, then you can go past that and recover from the trust. The next question, are there any types or categories that are not allowed? Not when it comes to personal property. There are certain types of what we call economic losses. There's something called the economic loss rule. And the idea is that because liability has to be cut off at a certain point, if you had a business that was not physically affected. So if, for example, you own a restaurant in a town in Napa and you lost business, not because you suffered any damage, but because people weren't coming for a couple of weeks, that would be barred by the economic loss rule. That's a kind of a specialized issue, but it is an example of limitations. For 99% of our clients whose losses consist of real property, personal property, lost wages, and emotional distress, no, there really are no limits. But if you have questions, let us know and we can talk about the specifics of your case. Okay, going to the next question. Is there a baseline amount for all claimants to start with, and then additional funds are awarded based on additional circumstances? You know, that's a good question. I don't think they're going to do that. They haven't made up their mind yet in terms of what the final claims resolution procedures are going to look like, but I think it's very unlikely that they'll have a baseline amount. The only way that they may do that would be when it comes to something like personal property. We talked a lot about this a couple of months ago, and I was one of the people that prepared this proposal and submitted it to the trustee during our working groups. We were trying to get them to use just kind of a flat number that people could elect to take. For example, 60% of the cost to rebuild, something like that. They've decided not to do that simply because
Hey, Jared, can you unmute yourself?
Okay, can everybody hear me?
Yeah.
Okay,
You're
great.
good, Jerry.
So we talked about that. It doesn't look like they're going to do that, but one of the things they may do, which is kind of an offshoot of what this question is they may say, for example, we're going to set a low amount for personal property that without having to show any type of list or documentation you can get, and then if you want to go above that, you can do that. That's an idea that's been discussed. We don't know whether or not it's going to happen. But again, my strong advice to everyone is if it's possible for you to make a list, please do so. We really can't make sure that you get everything you're entitled to unless you make a personal property list. Okay, next question. Is there any accounting compensation for the increased cost of insurance caused by the fires? Yes, this is something that you can claim. So if you can document that, for example, your insurance was canceled, you had to go out and buy a new one and it was more expensive, or if right after the fire, your insurance company raised your premiums, you can claim that. So please let us know and get us the documentation. Next question. As I understand from an earlier town hall, attorney fees will be paid from the individual claimant payments. Is that true? Yes, that is true. So the way that it works is that there's going to be an economic loss component. Then on top of that, the trust is going to pay your attorney fees on that economic loss component. So whatever that is, they'll add the attorney fees on top. Then on top of that, they put in the non-economic damages, and then we, the attorneys, are paid from that total amount. So that's how that works. Both the trust and the individual pay a portion. The trust pays the attorney fees for the economic damages. The individual pays the attorney fees for the non-economic damages. And again, the reason it works that way is that under normal circumstances, you do not get to recover your attorney fees. Inverse condemnation has a fee shifting provision, which requires the losing party to pay for the attorney fees, but only economic damages are available. And that's why only economic damages are eligible to have the attorney fees paid by the trust. Okay, next question. If the settlement is half stock and half cash, I assume that half the payments to attorneys will be stock as well. Again, the way that it works is that the trust is going to be funded half with cash and half with stock. However, the stock is not going to be given to anyone. It's going to be sold by the trustee to raise the cash that he is going to need to pay the claim. So the initial payment that's going to be made in cash is $5.4 billion. That will occur on or before August 29th. It will likely take at least 6 months to get through that $5.4 billion. Once that's done, then the trustee will start selling off stock bit by bit in order to raise the cash that's needed, but no one will be paid in stock. Some individuals expressed a desire to be paid in stock, as did some attorneys. The trustee looked at it, but ultimately said that he was more comfortable just making sure everybody was paid in cash, then people could buy whatever stock they wanted. So for those of you who wanted to get paid in stock, I apologize. We did make the request, but the trustee was pretty adamant about that. Okay, next question. It seems likely that some of the awards will be sizable in this case. Is there any guidance you can provide regarding the tax implications of awards? Is there anything special about this case that would reduce the likelihood of tax liability? Is it advisable to review your case with a tax attorney at this time? The answer to that question is yes. You absolutely should talk with a tax attorney or a qualified CPA, and we can certainly recommend some for you if you'd like. There is a CPA that we've referred people to in the past who specializes in these kinds of disaster cases. So he's very familiar with the laws as it relates to these specific types of awards. The general rule, and again, there's a million exceptions, but I'm certainly comfortable telling you the general rule. Again, I cannot give tax advice, but this is just a general rule, so it's not necessarily applicable to your case, but it is the general rule. The general rule is that if you receive money to compensate you for lost real property or personal property, and you actually replace the real or personal property, then generally speaking, there is no tax consequence because no taxable event has occurred. You haven't received any kind of a benefit, you've merely been compensated for a loss. And in our system, the way that we compensate people is with money, not by replacing what it was that they had. So that's the general rule. Now, again, there's a million exceptions to that. The most obvious one is some people will take a loss on their capital gains based upon the loss that they incurred to their real property during the fire. Now, obviously, if you do that, then anything that you receive would be a capital gain. So if you take a capital loss and you get an award from the trust, now you've got a capital gain. So that's just one obvious example of where the general rule doesn't apply. But again, this is a very specialized area of law. We are not experts in it. We cannot give tax advice. So I strongly recommend that if you have any questions, talk with a CPA or a tax attorney. Okay, next question. Do we need to file for the trauma part of our claim, or is that automatically part of our claim? That is something that we will prepare for you. You definitely need to file. The way that they're doing this is that there are a number of questionnaires that we're going to be filling out for each case. So if you are claiming real property, then there's a specific questionnaire that we fill out, and then we attach all of the supporting documentation. If you're claiming personal property, same thing. Same thing if you're claiming any type of trauma, emotional distress, the so-called nuisance damages, and I know that it's a lot more of a nuisance, but technically under the law, the annoyance, inconvenience, mental anguish are referred to as nuisance damages. So anything like that, we will be preparing for you, but yes, that is something that has to be claimed. Next question is, the first settlement check will be for 75% of our claim. Can we sell then, or should we wait until the final 25% has been released? Again, when I said 25% would be withheld, I was using that as just a general idea. It could be more, it could be less. So I just want to make sure everybody understands that. It certainly wouldn't shock me if instead of 25, it was 20% or 30%, maybe even higher. I really don't know what that holdback is going to be. I just know that there will be some holdback. In terms of the substantive part of the question, that is, can you sell? Obviously it's up to you. Again, you have to be able to truthfully say that you do intend to rebuild. So if you do not intend to rebuild, then you cannot recover for the cost of cure. But if you're in that position where you're waiting to see if you get enough money to rebuild before you make a decision, and you know what the final amount is, and it's not going to be enough to rebuild, then I don't think there would be anything wrong with selling your property after you receive the initial portion of the settlement. Again, it's very important. You do have to say under penalty of perjury that you intend to rebuild. So if you don't intend to rebuild, obviously don't say that. But in terms of selling your property, if you get your final award and it's not enough to rebuild, so you're going to be selling your property, then you can certainly do so at that time. Next question. Once I submit all of my proof, will I have a phone interview with my lawyer? Yes. This is something that we've been doing for quite some time. Typically, that's the last piece of the puzzle that we do. So we wait until we have everything else, then we get the interview done, and then we submit. So people who have that, generally it's done because every other part of their case is complete. But if you want to get yours done earlier and don't want to wait, no problem. Just contact the office and we can go ahead and make an appointment for you to get that done. All right. Next question, is there any required documentation to verify loss if you only have a PTSD claim? It depends is the answer. You have to be able to meet what we're calling the gating requirements, which, and this, I know nobody on this call would do it, but there are concerns, obviously, that we don't want people who were not actually affected by the fire to make claims because it is a limited fund. So one of the things that we're doing is putting these gating requirements in place to make sure that we establish that someone actually does have a claim. So if your only claim is PTSD, then you would have to explain what you were doing there. In other words, if, for example, you didn't live at a home in Paradise and have to evacuate, why is it that you were evacuating it? And there are certainly a number of very legitimate reasons. You could have been staying over with a friend, fire comes, you have to evacuate. You could have been working there, could have been delivery, any number of things. It's just that if there isn't a ready explanation as to why you would have been in that space at that time, then we may have to provide some kind of documentation to get past that gating requirement. Moving on to the next one, in terms of whether or not you have to have documentation to make an emotional distress claim, you do not. If you have a severe emotional distress claim, in other words, if you are claiming that because of your PTSD diagnosis, you were unable to work for 6 months, a year, something like that, then you will need to provide medical documentation. But if your claim is going to be, and obviously there are no standard claims, but if your claim is going to be what we normally see here, which is that I fled my house, the fire came, I was terrified, that's completely understandable, and you don't need to provide any medical documentation for that. Okay, next question. Our insurance, Merced, filed bankruptcy, and CIGA, California Insurance Guarantee Association, took over our claim. They put limits on all 3 categories, which was not enough to rebuild. Their own estimates were much higher. So in terms of the question is, which of the limits is going to apply, the original or the CIGA? It's going to be the CIGA. It's what you reasonably could have obtained. So it didn't matter if you had, for example, $1 million insurance policy with Merced. If CIGA comes in and says, we're sorry, but it's only going to be $500,000, then absolutely, the insurance policy limit that you have to exhaust is $500,000. You can't be expected to exhaust something that was impossible as a matter of law to exhaust. So, okay, those are the written questions that we got in advance. So I want to open it up. Let's see what questions everybody has, and we can go from there. Who's first, Chewy?
I do have a submission here. It's a 3-part question.
Mm-hmm.
It says, during the documentation collection, should we be thinking in terms of individuals? And when should we be thinking in terms of household? We are a family of 2 parents and 2 kids. Do we look at the content strictly as household and the personal impact as individuals? And will the award be paid out to each individual in the house or to the household as a whole?
Okay, couple of different components there. So let me take the second one first, because that's the easiest one. In terms of how it's paid out, typically, if you're a household, a family with a couple of parents and 2 or 3 kids, let's say a family of 4 or 5, ordinarily it would be 1 payment that is done. Now that said, sometimes there can be situations where it just doesn't make sense to do that. If that's the case, and one example is, there are times where you might have parents that get divorced. And they're not amicable, and so it just makes more sense to keep things separate. Half payment goes to one, half payment goes to another. If you would like to, within your household, have 1 person broken off or 2 people broken off and have separate awards, you can absolutely do that. We just need to submit the claim separately, and then they'll be calculated separately. So just let us know. That's not a problem. We can absolutely do that. In terms of how you should do it, typically it's best to have the narrative of the family. I mean, you want to describe what everyone went through. If they were together, that's easy. If they're not, then make sure that you get everyone in there. So you certainly want to consider everyone as individuals, because sometimes, particularly if one spouse was at work, something like that, there will be very different stories in terms of what they went through, and that can be important in terms of the emotional distress. And also there can be differences in terms of how people deal with the fires. Some people have much more significant reactions than others do, and if that happens, you want to make sure that you cover that. Okay, what's next?
I don't have any more submissions here on the chat.
All right, let's take questions from the board. Who has questions?
Whoever has a question can unmute themselves, or if you're on video, give me a wave and I'll unmute you.
Hi, I had a question.
Yes.
So, question regarding insurance. So, if we have, for example, a $60,000 clause on our policy for additional building costs, but we're not sure what the heck we're going to do, will the claim, will that be deducted from our award even though we don't know what we're doing?
Yeah, the answer is it depends. If you were going to go with the cost of cure, meaning that you wanted to repair everything, then because the 60,000 would be available to you, then yes, it would be deducted. However, if you were going to go with diminution in fair market value, in which case the 60,000 would not be available to you because it's only for overages in actual construction, then you would not have to consider it. So it's like most legal questions. The answer is it depends. But if you're going to do the cost of cure, which is the standard one that we do, where we have cost to rebuild, trees, everything, then yes, it would be considered, because as long as you do the build, you will get the 60,000.
Okay. Thank you.
Sure. Yes, Ms. Kingsley.
I had two questions. Let me
Yeah.
start with the first one. If I'm dealing with a nonprofit organization and we're self-insured, so there's no, quote, insurance policy. How does that work?
Yeah, that's not a problem. Anytime you're self-insured, it's like you have no insurance. So that's not a problem.
Okay. My second one is I had a friend that died in one of the fires.
Oh, wow.
So
I'm
my
sorry.
question is this: on a PI case, normally you would calculate, what the value is of what that person, could earn during a lifetime or whatever. So how is this calculated by a trustee?
You mean for a wrongful death?
Well, I mean, they died in the fire.
Yeah. So that's the cause of action is considered a wrongful death.
Okay.
In terms of wrongful deaths are very case specific, because you're looking at two separate things, and both of them depend upon the relationship between the decedent, the person who died, and the heir. If the heir was dependent upon the decedent for income, if, for example, it was a child, it was a spouse, or in some cases parents, as long as they received a certain amount of their support from the decedent, then they can go ahead and make a claim for the earnings projected out throughout the work life of the decedent. In terms of the other component, which is the loss of love, comfort, society, and affection, that again is a case-by-case thing. It depends upon what the relationship between the heir or heirs and the decedent was like. So obviously, the closer the relationship, the more that's going to be paid. And again, I'm sorry for your loss.
That's all right. I appreciate your answer to that question, because I didn't know, how it was going to be. They've talked to me a couple of times. So I'll have him get in touch with you. The other thing too is to clean up the site, because there was, because of the pollutants. That is a separate number than that, we would give to you as to clean up the site. Okay.
Yes, and there should be, if you're talking about the self-insured, then it's not an issue. But if it's not a self-insured situation, then there will be a portion of your insurance that will be for debris removal. And once you exhaust that, and it's not a lot of money, so everybody exhausts it, then you can recover over that.
Thank you very much.
Okay.
I believe Mr.
Okay,
Parsons-
who else has questions?
Come on, people.
Mr. Persons?
Yes, we were part of the Butte fire, and that's in Calaveras County.
Yes.
We live on 5 acres, and we had trees like Yosemite. We have 4 trees that have kind of made it. The PG&E, their subcontractors came in and cut the bigger trees, but we've still had somebody come in and cut some other trees. But they have left 20-foot lengths, like Lincoln logs, laying out in different places in our property, and the lumber mills won't take them, and so they're just out there. And our insurance paid us $26,000 for the loss of the trees. So what do we do about getting rid of those trees? And what do we do about the trees that have been lost in the fire?
Sure. Well, in terms of Butte, it's a little bit different because some of the reports that we have were prepared so long ago. And so you may have lost additional trees. Has that happened in your case?
Well, only 5 did not burn, and they are standing and they are growing.
Okay.
After the fire, I went and counted all the stumps.
Okay.
I don't remember the exact number, but it was 295 or thereabouts.
Oh boy. Yeah.
And they allowed so much for a tree, but the limit was not.
Yeah,
Yeah.
Yeah.
The limit's low. So what we need to do is make sure that you get enough money so that if the logs can't be sold, then they'll have to be chipped up. That's really the only thing they can do is chip them and mulch them, and that way they won't be a fire hazard for the future. Have you been able to review the arborist report that was prepared in your case?
No.
Okay. If you could just send, go ahead.
You're the attorneys, I don't know if it was you or the Royce, but I don't remember, but the team came from the insurance company and surveyed everything. You should have that report on file.
Okay, let's do this. Can you just send me an email or call my office tomorrow? And what we'll do is we'll get you a copy of the report. Please take a look at that. And if there's anything that needs to be added because there's been additional losses, let us know. If not, then the report should be good.
Okay.
Okay. All right. Okay, who's next? Yes, Mr. Go ahead. I think you're on mute. Wendell, I can't see your last name. Whitmore. Go ahead.
All right. So I was on the Feather River Canyon side. So I had 5 acres.
Mm-hmm.
So I got 3 trees left out of 680.
Oh.
So PG&E came through and same thing. They cut them all down. They took what they wanted and left me the rest. So will they, how do I go about replanting?
Right, and that's what the arborist report is for. So what the arborist report will do is they'll come up with a plan that will encompass all of the aspects of your loss. It will include the cost to get rid of any trees that have been cut down but are still on the property. It will include the cost to replant smaller trees, and then it will include the aesthetics for the time it will take, which obviously will be many, many years, before the trees approach what they look like before. So those are the three main components of the arborist report. If you haven't seen a copy of yours, let me know. Again, just send me an email and we
Okay.
can send you a copy. You can take a look at it.
All right, thanks.
Okay. All right, who's next?
I'll try. Hello?
Yes, go ahead.
Okay, I'm Richard. So we had a house in Magalia. We lost everything. We were grossly uninsured and did not know that we were not supposed to sell the property to be able to maintain our best position. This we just heard recently on one of your town halls. So we will put together a list of our personal property. We will be able to put together a list of pretty much everything. But where does that put us in regards to the property being sold?
Right. Well, the way that works is that you can still recover. A lot of people think that if you sell, you can't recover for real property. You absolutely can, but it is limited to the diminution in fair market value. So if your property's worth $400,000 a day before the fire, and after the fire it's worth, you know, 10,000 or 50,000, whatever it is, then the difference between that is what you can get. Typically, it is less than what you would get for the cost of cure. And so I'm certainly sorry that you're in that position, but that is the measure of damages that you can recover.
Who calculates the value of the property on the 7th of November?
We have appraisers. There's their MAI, which is the designation. That's the license that they have. And so you'll get an MAI appraiser. They will come in and they will say, before the property or before the fire, we believe the property was worth X. After the property, we believe it was worth Y. And obviously, we use the same couple of appraisers for these, so they're very familiar with property values in these areas.
So the other part of this is I was under construction, remodeling the entire place.
Mm-hmm.
This remodel was documented by Foremost Insurance because part of it was a damage settlement on water damage, and then part of it was an upgrade on our part. And we were in the process of a whole new kitchen, bathrooms, and an exterior deck that was under construction at the time. And Foremost backed out and said they won't touch it. How do we put that together?
You mean in terms of explaining to the appraiser the changes that have been made to your house?
Yes.
Yeah, that's something that you're going to have a conversation with her and just go through and explain, here are the differences, here are the documents that we have. This is why the property was different than what you'll see when you look at the county records. And then she can take that into consideration.
So pictures are going to play a big role in this.
Yes, if you have pictures, that'd be great. I know a lot of times people lost their pictures, but anything you have, anything friends or family may have, social media accounts, phones, that's all very helpful.
Thank you much.
Of course.
I have a question.
Sure.
First of all, thanks for doing these Zoom meetings. I've been hearing through the gossip mill that when it's time to start selling off the stock, that who's ever in charge, I don't know, stock laws, whoever's in charge of selling stock is going to require that take a 5 or 6 year period, thereby slowing down that last 25% or whatever it's going to end up being. Is that true?
It's not. The 5 to 6 years was a statement that was made. It was made by an attorney named Bob Julian at the hearing last Friday, and JD Morris, who's a reporter for the Chronicle, picked up on it. And as I said to JD, you know, look, I'm not saying that you misquoted anybody because you didn't. He said that. But the problem is that statement was not factually accurate. And so now it's out there and people understandably are worried. What Bob was trying to do was make an argument to the judge as to why our view of the registration rights agreement should prevail and everything should be the same. And in so doing, rather than saying it will take longer, he did what attorneys do sometimes and engaged in a little bit of hyperbole and said it could take 5 to 6 years. Well, theoretically it could, but no, it's not going to. And we got the registration rights agreement we wanted, so it's not an issue. So I completely understand. No one's lying. That statement was made. It was, unfortunately, though, an attorney, you know, again, engaging in hyperbole. So there's nothing to worry about. It's not going to take 5 to 6 years.
Okay, thank you.
Sure.
I have a question.
Sure.
My name's Cynthia. On the claim, I have numerous, I mean, really numerous things that I want to include with my claim, receipts and other things. Okay. And it looks like the 2 ways, at least as I understood it, that you can submit are either by fax or by email. And either of those processes is probably going to be not very functional for the number of things that I need to submit. So I just wondered if there was another option.
Yes. Yeah, absolutely. Where are you located physically?
Southern California.
Okay. In LA, San Diego, what part?
Encino.
Okay. We have an office in the Ventura area. So I think the best thing to do would be to have one of our people come over with a mobile scanner, and then they can scan all of your documents in. I think that probably would be the easiest for everybody, if that makes sense.
Okay. And okay, can I ask you, sorry.
I was just going to say, again, if you could just email me so that I have that information, I'll forward it to the head of our Ventura office, ask him to get in touch with you, and then you can set that up.
Okay, will do. And I wondered if you had any idea, I know you had to do extra work, a lot of extra work on our behalf for the Tubbs fire. Do you have any guesstimate about what the amount we will be deducting from our compensation towards those costs?
Yeah, that's a good question. The only thing I can say is that the Tubbs damages are going to be higher in terms of the cost. The costs that are going to be associated with that are higher than the other ones, simply because we did do so much more. That said, there are so many Tubbs plaintiffs that it's going to be spread out. So it's going to be less than the 2%. You know, we always talk about it's going to be less than 2%. It will be less than 2%, but whereas in camp, it's almost nothing. In Tubbs, it will be something. My guess is it'll be somewhere between 1 to 1.5% of everyone's total amount, simply because there was just so much more work that was done there.
Okay, thank you very much.
Sure.
Thank you. I have my hand raised.
Please.
Oh, okay. I'm Bruce Persons, and I represent my brother Earl. I think I spoke to you about a month ago on a previous.
You did, but you didn't have the Golden Gate in the background last time. All right.
That's true. I didn't. Yeah. It's awful cold out here.
I bet. Yeah.
No. Okay. So in regards to the last question that you answered, the attorney's fees for the campfire aren't going to be as high as those for the Tubbs fire?
No, the costs. So remember, there's the 2 different things. There's the fees, and then there are costs that are associated with proving up the liability.
Oh, I see.
And so those are advanced. But again, with camp, I think we had one expert that, you know, may have made one site inspection, so it's negligible. Whereas in Tubbs, unfortunately, we had to have a full team, and we got within 2 weeks of trial before we settled that one.
Okay. my next question goes back to the subject of the trees.
Mm-hmm.
If I heard you correctly, Earl can be compensated for the loss of his trees.
Yes, absolutely.
But he can't be compensated for trees that are still standing.
Well, it depends. If the trees are damaged but are still standing, then yes. But
Okay.
that's a little bit different situation. So what will usually happen is the arborist will go through, and there are a lot of times where trees will survive a fire, but will be so damaged they'll die within 1, 2, 3 years, something like that. So the arborist will put that down in their report, and they'll include that tree as being damaged, and they'll say, we're going to need X amount of money to remove the tree once it dies. So
Okay.
that is usually put into the report, but that's one of the reasons we circulate the reports if anybody wants to look at them, and then they can say, I think that, you know, instead of having 25 trees that died, I think I had 30, that kind of thing.
So the arborist reports are site specific?
Oh, yes. Yeah, there's a report for each property that will be making a claim for loss of trees.
Okay, all right. I will email you for a copy of that report then.
Perfect.
And then regards to the subtraction of the insurance payments,
Mm-hmm.
is that, in layman's term, is that what I hear? That the the insurance payments would be subtracted from the claim?
Right, and there are times where there's one category where people didn't exhaust their insurance and are still making claim. So the trustee is requiring people to either go back and exhaust, and that's personal property. If someone, for example, didn't exhaust their personal property, but now wants to get the full amount, they have to go back and exhaust it or show why they made a reasonable effort but couldn't do it. And the reason for that is we don't want the insurance companies to be able to avoid paying their fair share since we have this limited fund.
Okay, so in the case, in my brother's case, the insurance company paid him a certain amount and said they weren't going to pay him anymore.
Right.
So in terms, in lawyers' terms, he has, Earl has effectively exhausted his claim because the insurance company won't pay anymore.
Right, and so here's what we need to do. If, for example, they paid 75% of the claim but not 100, then if he wants to make a claim for more, and if, if, for example, he doesn't have a list that would show why it should be more than that, which is what he'll need to submit to the trust, then there's really nothing to do. But let's say, for example, that since then, he has made a list and it comes out to 150%. What we need to do, and we're happy to help you with this, is submit that claim to the insurance company and say, you paid 75%, there's another 25% you owe, pay that now. And the benefit of that is that because that's insurance money, there's no attorney fee on it. All of it would go to your brother.
Okay, to be specific, we submitted a personal property list that was about 139,000, and he was only paid. He was paid less than 100,000 on that.
Okay. What we should do then is, this is something we should go through specifically in your case and see if we can get the rest of the money from the insurance. And we're happy to help you out with that.
Okay, so you will need proof of the dollar amount that he's received.
Right.
Is that right? Okay.
Yeah, and we can get that from the insurance file, so that'll be easy to get.
Oh,
What we need is the list, and then we can
You
have one
have
of our
the list.
people.
Yeah,
Okay,
we
great.
submitted the list.
Okay, perfect. So what we need to do now is, if we didn't, or if he didn't max out his insurance, we need to resubmit the list with a demand to pay, and then we can take it from there.
Yeah, I'm going to talk to him again tomorrow. He had his eyes worked on today, so he wasn't going to be able to sit in on this meeting.
Okay. I hope he feels better, and just please email me tomorrow and we can take a look at that.
All right. Jared, I think Ms. Tunis has a question.
Yeah, I thought I heard Jessica. Jessica, did you say something?
I didn't realize I was unmuted, so I don't know what.
Go ahead.
Pardon my.
Yeah, he's feeling much better because he can see a whole lot better now too. So.
Good. I'm glad. All right. Thank you, Bruce.
I'm here with John.
Go ahead, Jessica.
So you can hear me okay? So my question is, you said that the trust you think will be funded by the end of August. In the past, you said they're trying to push it to the end of the year. So did that get solved in our favor then? Are they going to pay it on time?
Yeah, I mean, again, there's no guarantees, but it's the date that's in the agreement, the RSA, has always been August 29th, and they've consistently said that they were going to pay it by then. I talked with the main finance guys from PG&E and their attorneys over the weekend to see what they thought the actual timing was going to be, and they were very optimistic. They thought they were going to be able to get it done in advance of August 29th. So again, there's no guarantees, but that's what we think it's going to be. And again, if they don't fund it, then bad things start happening to them pursuant to the deal that they made with the state of California.
Okay, thank you.
Sure thing.
Another question. This is Cynthia. Is that okay?
Sure, go ahead.
You had indicated in a previous town hall that there was consideration about whether victims' compensation would be confidential, and it hadn't yet been determined. Are we at that point where it's been determined as yet?
Yeah, it's going to be confidential. The trustee always wanted it to be confidential, as did we. I mean, we feel like it's people's personal business, but there was an objection that was filed by one plaintiff, and they wanted everything to be public. So that was one of the things that got worked out. The way that they resolved it was that the judge said, if you're concerned that, something nefarious is going on, you can come back in, you can explain to me what it is, and then I can decide if there's any basis to take a look at these confidential resolutions. But I'm not going to just get rid of the confidentiality because you're concerned without having any specifics that something in the future could happen. So it will be confidential.
You mean facts will have to be actually provided?
What's that?
The person would actually have to provide facts as opposed to...
Exactly. And I don't think this is going to come up. This happens sometimes. What happens is there were a couple of businesses, and what they were trying to do was to essentially, for lack of a better term, they really were just trying to blackmail the trust. What they wanted to do was insert provisions or demand that various provisions that we didn't want be inserted. And then if they would have won that with the judge, they would have said, okay, as in exchange for taking this out, we want you to overpay our claims. Boy. So we're very happy with the way that it went. The judge did not grant any of their requests, so that didn't work.
Good job. Thanks.
It was a lot of people that were involved, but thank you. I appreciate that. All right, who's next?
Rose O'Malley.
Hi, yes, I just had a question regarding, you said that we were going to get a settlement based on a household, but what if I had people visiting from out of seas, from Europe and South America during that time? Will they get compensated because they filled out claims as well?
Yes, yeah, and I was a little bit imprecise there. By household, I just meant, it doesn't have to be the same address. I just meant people that have basically the same interest, the same claim. So a nuclear family. But when you have somebody who's staying with you, their claim typically is separate because usually they have no interest in the real property, and oftentimes their personal property is very small. They might have the clothes that they brought with them on they travel. So those claims are resolved separately, and as long as they make their own separate claim, which it sounds like they did, it will not be considered part of your claim.
Okay, thank you.
You have Mr. Ron Amberg.
Okay.
Yes, I had sent you a question about evidence, or how do you document the trauma from the fire. I rent, and so it displaced me. 2 months before the fire, I did have fire insurance after living there 20 years. So the fire insurance covered me, but I didn't realize I had a high deductible. So any contents that were not salvaged, which was, just the smoke and ash damage, I just disposed of a lot of things. So primarily, I was concerned about the trauma from the fire that had gone on and still continues as a result of it. Should I continue my claim?
Yeah, absolutely. And the way that we do that is that it really is done through a narrative. So they're going to look at some objective factors. For example, for people making what we call pure emotional distress claims, they're going to see how close you were to the fire, for how long, that sort of thing. For people that are making claims, and this comes under the category of nuisance damages, obviously it's much more serious than nuisance, but talking about the loss of the community, the fact that you lost everything you own, your home's gone, or whatever your individual story is, we go through and we describe that, and there are certain objective factors that they look at, but at the same time, this really is the most subjective of everything. And so that's why the claims administrators that we have chosen are people that have a lot of experience with this, because they have a sense of what these cases should settle for based upon prior settlements, prior verdicts, that kind of thing.
Well, I had, for a number of months, I had mental health support, which there was no payment for it, but it was provided, and I really didn't want to get involved in having to document that, but other than that, it's something that continues, or even just talking about the matter, it affected me quite a bit.
No, and that's understandable. So I think the best thing to do is we should have a talk offline and decide whether or not you want to include those records. There are pros and cons. And so because it's a confidential matter, I think we should have a talk offline, but let's do that and we can decide whether or not it's in your interest to include the records.
Okay, thank you very much.
Of course.
I have a question, and I'm on the phone, and my name is Linda.
Okay.
I have two questions, actually. One is about the tax liability. I was a professional artist, and my husband also painted, but we had a separate art studio in the back of our property that burned in Paradise in the campfire. And as a result, we lost our life work. Well, I had a website, and, I sold originals through that, and also through galleries at one time, but then I gave up the galleries as I was coming to age and didn't want to go through that. But how do my website is still up. I've had to say that all originals are no longer available, And I've been trying to find a way to reproduce as prints because I've had inquiries from former clients who also lost originals of mine and want them replaced as prints, but we're having difficulty because technology has changed. It changes so fast that even between the time of the campfire in early November and the time we got our feet on the ground, about 4, 5, 6 months later, all of the programs had changed. And now I'm having issues with my JPEGs and stuff like that. So how do I figure out what my potential would be on the print market?
Oh.
I mean, everything is gone, right? I mean, I got out with my Seagate hard drive.
Yeah.
So I had my oeuvre, if you will, my work in there. But it was from, I've been working as an artist since the 1990s, or all my life, actually. And there are programs, I don't know, I can't even explain the different platforms that these images were in. So I don't know how to compensate for lost income, potential income.
Yeah, no, and that's a dicey one. So there's a couple of different ways you can do it. One way is just to look at what the average income you've earned over the past few years is. And if it's fairly uniform, then that becomes pretty easy. You can just say, I estimate I would have sold a similar number of paintings. However, if it fluctuates, which it certainly might, I know that being an artist that sometimes happens, then it can get a little bit trickier. I think this is one that we probably are going to need an expert. I don't know that this is something that I would be comfortable trying to calculate without at least consulting with an expert to go through your financials and see if there is a way that we can present a clear picture of just what your losses are.
Okay. All right. Well, I'll work through that. And anyway, so the other question is, so we have not sold, we had 2 properties in Paradise. One was our main property on the Pence Road side, and then the other one was a rental that also burned. And we have not sold either property. We have relocated to Oroville on a beautiful property, but we had not thought about rebuilding. However, if the amount that we receive in the settlement is appropriate to consider a rebuild on our main property for a second home, would that be something that the courts would consider?
Yeah, no, that works. I mean, remember, you can rebuild and then sell the property. That's fine.
Oh, okay.
So, so what I always tell clients is, if you're absolutely sure you're not going to rebuild, then no problem. You just say that and you move on and we do DIV. But if it's one of those things where, and this is frankly where most of my clients fall, they're saying, I'm going to do whatever's in my best interest financially. And so if it makes sense for me to rebuild and sell, then I'm going to do that. If I can get enough money from the settlement to rebuild, then I'd like to do that. So generally speaking, it's absolutely acceptable to say, I'm interested in rebuilding, but I really can't make any decisions until I know what I'm going to receive, because that's going to inform what's in mine and my family's best interests.
Very good. Okay, thank you very much. And thank you for doing this. Really appreciate it.
Mr. Singleton, I have a question in the chat area.
Sure.
if Chewy wants to just look there about the trees.
Oh, great. Chewy, can you take a look?
Thank you.
Yeah, I'm sorry. Who was that speaking? I'm sorry.
I just put the first initial of my first name, D. That's for David.
Got it. Let me get to that question. Okay. The question is, there are no logs in my yard that were not my trees, that were not there last summer, that someone, I'm assuming PG&E, dropped in my yard since then. Any suggestions?
That is unusual. Yeah, I mean that's kind of out of the ordinary. If PG&E and sometimes they do come through because they are taking their duty to trim the trees more seriously now, so it easily could be them. But we'd obviously have to establish that PG&E is the one that did it in order to hold them accountable. So the first question is whether or not those logs are within their easement. If they are, then that's pretty strong indication that they were the ones that cut them. If they're somewhere else, then that's a separate issue. So that's probably something that it's kind of unique, so we should talk offline. If you want to just send me the information you have and why you believe PG&E was the one involved, we can take a look and go from there.
Okay, thank you.
Sure.
I do have another question here in the chat. It says, will the first person or claim to receive a payout from the cash portion of the settlement be the first to receive payout from the sale of the stock?
No, it's a little bit different. The way that it works is the cash payments are going to start probably in October. That's what the judge told us, Justice Trotter, the trustee, when we spoke with him last week. Could be a little earlier, could be a little later, but October is what he is setting his goals for. And the first person will receive not the entire amount, but a portion of that. And they and everyone else will receive the second portion at the same time. What will happen is Justice Trotter is going to withhold a certain amount. Again, it could be 25, could be 20, could be 30, something like that. And then once he determines, consulting with his financial advisors, that there's going to be enough to pay everyone, then he'll release the balance. If it turns out that there's not going to be enough, if everyone can only receive 95 cents, 90 cents on the dollar, whatever that amount is, then he'll wait until all the claims are resolved, and then he'll pay everyone a pro rata share of that last amount. So the first person to get paid will obviously be the first person that gets the cash, but in terms of the sale of the stock, that's just going to be done on an ongoing basis in order to fund the payments. And the receipt of the amount that's held back, whether it's 25%, 20%, whatever it is, that's going to depend not on the sale of the stock, but on the trustee being confident that he has enough money to pay everyone 100 cents on the dollar.
I have Mr. Brian Mills has a question.
Okay.
Yeah, thank you. I'll try not to make this too complicated, but I actually have a couple questions. Just I want to make sure when I put the documentation together, I do it correctly. For the insurance portion of it, when we talk about determining what insurance hasn't covered or is not set up to cover, is it simply just based off the declaration page, or do we need to provide some sort of proof of what has been paid out by the insurance company or what they intend to pay out? Like what documentation needs to be provided for that?
Yeah, it's usually the declarations page, but remember the trust will have access to the insurance files because they're being downloaded as part of the subrogation claim into Brown Greer. So you don't have to provide anything there. They'll have access to the declarations page and the amount paid.
Okay, and so most of us, I'm pretty sure, aren't rebuilding the exact same house we had before.
Sure.
So there's obviously some gray area and really undefined things in terms of what it exactly would have cost in today's dollars and today's code requirements to make the exact same house or the modern representation of the same house we used to have now versus what we're actually building. So how is that determined? What is needed to determine that?
Yeah, no, that's a good question. The way that that works is that our expert, and this is why we don't take the cost to rebuild the home that is being rebuilt, because as you indicated, most times, I'd say 9 out of 10, there are differences. And so what we do is we say, based upon what it costs to build today, here's what it would take to build the exact same structure that they had, because that's what you're entitled to. If you build more, that's fine. If you build less, that's fine. But they have to replace what they burned, regardless of whether you built more or less.
Okay, so that will be that'll be provided as a service to us, essentially. We'll give as much.
Yeah, absolutely. Our experts, the contractors are the ones that do that, and we have several different contractors that do those workups.
Okay, great. Lastly, I did not have 5 acres of trees. I do feel terrible for the people that did, but we certainly had some mature trees on our property. That our insurance company, the way they had it outlined was they had a maximum $500 payout per tree. That's the most they would pay.
Yeah.
We don't have an arborist report for our property because that was never offered to us, or it probably didn't look like the kind of property that needed one. So what do we need to do to show proof that we had trees cost significantly more than $500 to replace on our property that we need to be compensated for?
Well, if it's going to be more than what insurance paid you, which it sounds like it is, then we need to get an arborist report. We can do them for properties that have less trees that aren't that expensive. You can probably do it for $500 to $1,000, and even if it's a smaller tree damage claim, maybe $5,000 to $10,000, it still makes sense to do it. So please just either send me an email or whoever you're working with, and let us know that you believe there should be or that there are tree damages that are in excess of insurance, and then we can get an arborist report done.
Okay, but it needs to be an arborist report. It can't be a collection of let's say, pictures by us of the actual trees and quotes for a tree that size and that type.
No, because the problem with that is they generally, sometimes they can replace like for like, but typically they're going to do it a little bit differently. And so that's why it generally doesn't work to say, for example, I went to, Evergreen Nursery and I found a box tree that was similar. This is what it cost. That usually doesn't work. So we typically do the arborist report.
Okay. Thank you.
You have, Jared, a question here. It says, our house has been rebuilt and it will be completed in August. If I get paid in September, can I immediately sell the house? Well,
first of all, congratulations on the house being ready in August. That's great. Yeah, you absolutely can. Once you rebuild, frankly, once you rebuild, you can sell because you've already rebuilt the home. I mean, there's no stronger evidence of desire to rebuild than actually rebuilding. I would recommend that you wait because you never know what argument people are going to use. But yeah, I mean, that certainly is evidence of a strong desire, the fact that you have actually gone through and rebuilt.
Jerry, I got a question. First of all, thank you. I don't know how you talk so much, but you do a good job. Anyway, I have a few questions. Now, Paradise is really messed up right now. My insurance is asking me, are you going to rebuild or aren't you? Kind of like pressuring me. And to tell you the truth, I'm not really sure.
Yeah.
I'm not really sure if I'm going to rebuild or not. It depends on a few issues, right? First of all, how much am I going to get from the settlement? If I get money from the settlement, I'll have more money for a better place to rebuild, or I might have enough money to not rebuild and go somewhere else.
Right.
I feel like it'll be 2 years, November 8th. And I feel like, and it's farmer's insurance. And I get a call, quite a bit saying, have you made a decision on if you're going to rebuild or not? And I tell her no. As a matter of fact, Jerry, they haven't even removed the dead trees. It's a mess up there. I paid for, we had a right to enter form we filled out. and I think my insurance paid $8,000. They're supposed to come in and remove the dead trees. Well, guess what? Every tree is dead. My neighbor's 100-foot pine trees, like 15 of them, all mine, the other neighbor. So even if I was to have mine removed, and I wouldn't put something there because the neighbor still has their trees that could come down and hit me. So they haven't even started removing the trees up there. And so it's really a mess, and there's a lot of different questions as far as, and I'm really confused on the additional building costs on my insurance, because I think they make it kind of hard to get. Mine is $50,000. And I think their job is to make sure that I don't get that for some reason. That's kind of the feeling I'm getting from this lady.
Yeah.
Now, if I was to move out of Paradise and buy a house comparable to what I had, and it was more money, would that additional building cost go towards that? I'm a little confused on that whole thing.
Yeah,
And also I'm confused on if I don't rebuild and I don't use the additional building costs, then my settlement will not be deducted that $50,000, even though I could use it?
Yeah, that's okay. So those are two good questions. In terms of the first one, it depends upon the terms of your policy. This gets very specific as to whether or not you can use the overage to buy a similar house. So what I would say is this. We have an insurance expert that we work with. His name is Joel Alba. If you want to send me your policy, I will forward it to Joel and ask him that specific question. He can review the policy, talk with you, and let you know what your options are. And this is not something we charge for. Joel works for us, and he's available for anybody who wants to talk with him. So I would really recommend doing that. In terms of the second question, yeah, that is going to get dicey. And I know there was a question earlier on this asking about that. My understanding of how the trust is going to treat that is that if you are asking for the cost to rebuild, they are going to look at the total insurance available as being your base policy plus that 50 overage, because if you rebuilt, you could get that. So that's my understanding of how they're going to do it. But I think it's worth me following up and asking. But I really would be surprised if they did it any other way, because when you think about the way that they're calculating this, that 50,000 would be available. So I do think they're going to deduct it.
Okay, thank you. But if you don't rebuild, then they won't deduct it, right?
Oh, absolutely. Yeah. If you say, look, I'm not going to rebuild, I'm doing a diminution in fair market value, it will not be deducted.
Okay, thank you.
Sure.
I have another question.
Sure.
Okay. What I did was relocate, purchase a lot, and used my insurance money to put a new home on it. Now, I submitted those costs to the insurance for the 20% upgrade and I think a 10% upgrade in code, as well as extended costs. They denied me. Now, the reason they said that was they took what I said I spent for the house and my costs. They took the policy, they took the amount of the original structure and the extended, or not the extended, but the personal property, added that together and said it did not exceed the amount to kick in the 20%.
Well, that's interesting. Yeah, go ahead.
Bit confused because 1, I paid X for the lot. 2, I paid for the building. 3, I paid school district fees and building permits and everything else. Yet they are denying me the 20% upgrade fee and the code upgrade fees, which I believe is 22% for the upgrade fees, and then the code was I'm going to say 7 or 10%. And
Sounds right. Yeah.
I'm trying to find somebody to help me out with that.
Okay, that is a Joel Alba question, because now we're getting into real nitty gritty of insurance, and he's our expert. So again, what we need is for you to send us the complete policy, then we'll send it to Joel, and Joel can touch base with you, but he is an expert in this area of insurance, so he can give us an opinion as to whether or not they are complying with their duties under the policy. And if they're not, it's simple. We just write them a letter, make a demand, and demand that they pay it. 9 times out of 10, that gets it done.
Okay, the other minor problem, may not be minor, but I contacted an insurance attorney, and he told me that there were funds that he would be able to get me, and that was 5 months ago. I have called this gentleman 5 or 6 times, and I am getting nothing in return. So, yes, I did sign a paper with him, and I'm assuming that I'm going to have to cancel that little contract in one way or another to be able to talk to Joel. Is that correct?
No, I mean, you're welcome to talk to Joel, because again, this is not something that we charge for. This is just part of the service that we provide. Joel's an expert. He works for us, so we make him available. If you're not happy with your other attorney, you may want to cancel that, separate and apart. I would, if you can't get a hold of him, I would just, write him a letter, make it very clear, say, look, I need to hear from you by such and such a date. If you don't, contact me by that date, then I'm going to have to terminate you. That's the way that I would handle that. In terms of whether you can talk to Joel, though, before you do anything with the attorney, it's fine. One has nothing to do with the other. This is just asking advice from an expert that works for us. So it's not a problem at all.
Excellent. Appreciate that. Thank you.
Sure thing.
Jerry, I have Mr. Brazil has a question.
Okay, great.
How are trees valued?
It's a very complicated question. There's a book called it's now the 10th edition, Guide to Plant Appraisal. And so these arborists all get credentialed, and they're very familiar with this, and there's just a million factors that come into it. The species of the tree, the size of the tree, the relative importance of the tree in terms of the function it serves on the property. Sometimes you have trees that are critical because they block a roadway, the noise, that kind of thing. You can have shade trees. You can have a tree that's, a signature tree, we call them, where, your driveway may have been built around it. All of those things come into play. So they look at all of those factors, then they come up with a value, but the value also has to be tied to the reasonable fair market value of the property. In other words, if you had a property with nothing but a bunch of beautiful, majestic redwoods on it, those redwoods might be worth a lot, but you can't have the trees be worth more than the property they're on. So it's a complicated way of doing it, and all of those factors are taken into account by the arborists.
State Farm is my insurance agent, and they, in writing, estimated I'd lost 600 trees.
Oh boy.
Part of that 600 trees was fig trees. I had a couple of dozen fig trees and about 30 nut trees.
Okay.
That were destroyed, along with oaks and willows. And then after that, I don't know when the arborist ever came to my property, but more trees have been dying one by one as time passes, big ones and little ones, oaks particularly.
Yeah. Well, I think the best thing to do is, again, either send me an email or just call the office and ask us to send you a copy of the arborist report. That way you can look at it and make sure you're comfortable with how they valued your trees.
So it'll tell me that, huh?
Yeah.
Okay.
And they are kind of lengthy. So, you know, I mean, there's going to be a lot of information. You can get as involved or as, you know, as superficial as you want, but it will provide you with all of the information regarding the number of trees, the overall value, all those things.
That's interesting. State Farm had to pay me for some trees, and their limit that they would pay was some percentage of my overall damage. I forget the numbers, but it turned out to be about $18,000 they paid.
Yeah.
At a rate of $750 a tree. They paid for 23 trees, basically.
Yeah. No, it's very unfortunate. Typically, those numbers are artificially set at about 5% of coverage A, and that's why it's so low.
That was just I paid for a rider in my insurance. Normally they pay $500 a tree. I have so many of them that I added a rider to my insurance, and it's $750, but it still didn't help me.
Yeah. Yeah.
You know?
All right. Well, yeah, Chewy just texted me that we do have a copy of your report that's available. So again, just either call or email tomorrow. We can send it to you. You can take a look and let us know if you're comfortable with the numbers.
I'll do that. Thank you very much.
Sure thing. Okay, who's next?
I don't have any more questions in the chat. I'm scrolling through here.
Okay.
I have one more.
Sure, go ahead.
One more.
Please,
I sent you guys an email related to being paid for personal property loss. State Farm pays you 80%. And holds 20% in reserve based on, and they'll pay you that too, if you go back and replace the items that you lost in the fire.
Right.
But this property has 25 acres, and it didn't burn our house down, but it burned everything else down in sight. And we just emotionally have not been able to deal with that. And now I've learned that I've run out of time because I have a 2-year limit on that 20% back.
Right.
Is there any remedy for that?
Yeah. If you, and you cut out a little, so I want to make sure I understood the question correctly. It sounds like what you were asking was your policy had 80% that was paid and then 20% was withheld, provided that you actually made the replacements. However, in your case, you did not, because of the stress and everything associated with it, you were not able to do that, and now the time for doing that has expired. Was that the question?
Correct.
Okay.
Yes.
Right. So to me, I mean, obviously it's up to the trustee, but that's a little bit different situation because now you're being told that you have to exhaust it, but you can't exhaust it because the time has been has already lapsed. So I think that will be treated differently. I mean, we can certainly ask the trustee, but the way that I view it, and certainly the interpretation that I would ask the trustee to make is, you are not able to get anything more than what you've received because the file is closed and there's no way to reopen it. To me, that's straightforward. We'll have to see how he views it, but that's how I would view it.
Thank you.
Sure thing. Okay. Do we have any other questions?
Don't believe so.
Okay. All right. Well, let's plan on talking again next week. I can't say with certainty that we'll have more information about the claims procedures. I certainly hope we will. If not next week, then the following week. But let's plan on doing another one on Thursday. We may not have a lot to report, but we can answer questions, and we'll go as long as people want to. So thank you, everyone. I'm excited. We're getting close to the end here. So hang in there, and we're going to get this done. Take care, everybody.
Thank you.
Bye-bye.